Hi, I'm Barbara McGinnis, certified elder law attorney and partner at Takacs McGinnis Elder Care Law. A common question we encounter when creating a trust as part of someone's estate plan is, does my trust need an EIN? That's an employer identification number from Social Security. To review, a trust is a legal entity created under state law and taxed under federal law. A trust may be created during an individual's lifetime, and we call that an inter vivos trust, or at the time of his or her death under a will, and we call that a testamentary trust. An inter vivos trust can be revocable or irrevocable. A revocable trust is considered a grantor trust and will use the Social Security number of the grantor for investment and tax purposes. The grantor is the person or persons who establish the trust and generally owns the assets initially contributed to the trust and may retain control over all or a portion of the trust assets and management. However, an irrevocable trust, which by its terms cannot be modified, amended, or revoked. For tax purposes, an irrevocable trust can't be treated as a grantor trust or a non-grantor trust, depending on the powers listed in the trust instrument. Once the trust has been created, a Federal Employee Identification Number, or EIN, is obtained from the Internal Revenue Service. Those trust funds are then invested under this tax ID number, not a Social Security number. A testamentary trust is another example of an irrevocable trust, but one created by a will, which begins its existence upon the death of the person making the will. Testamentary trusts are also non-grantor trusts and need an EIN. There are other circumstances in which an EIN will be needed for your trust, and your accountant or estate planning attorney will guide you. To discuss possibly using a trust as part of your estate plan to meet your estate planning objectives, call Takacs McGinnis Elder Care Law to set up your consult now.